hear me, please put the thumbs up so I can get right to it. I don't know what it is, but I bet y'all the niggas that don't tell. What the fuck? Y'all can hear me, please get me them thumbs up. Yeah, okay, y'all got me. Oh, y'all learning quick. Y'all ask the old people how to do it. All right, it was good with it. Damn, I promise you, I just looked up at one of these screens and shit. I saw some chocolate thumbs up. I said, okay, must they figuring it out. Okay, shouts out to you, old and new. What's good with it? Shout it. You was number one. What's good with it? Red Bunny, Red Bunny. Hey, Marietta Jones, Zoe, Karen J. Hey, Rose Flower. I never seen your name before. Hey, Love Spare. Welcome or welcome back. Hey, Queen Diva. Did I say Zoe? Yeah, I got Zoe. Hey, Stilettos for me. Hey, Over. Queen. What's good with it, Queen? Hey, Candy. Lady G in the boot. Hey, Danny. Hey, baby, Danny. Hey, Danny, baby. Hey, liar, liar. Oh, shit, it done jumped. Now made me miss my spot. Damn. Oh, I hope I ain't missing nobody. Wait a minute. Okay, liar, liar. T baby, what's good with it? T baby, I ain't seen you in a minute. Hey, baby. Hey, Samantha Nicole. Oh, it keeps jumping. Okay, let me check on something real quick. Okay. Oh yeah. Okay. So we got the judge's answers back. Woo! Child, this made me nervous. Oh man, where the people at? Why nobody ain't? Because this came out a minute ago. I don't know why nobody ain't talk about it. What the fuck is going on? Let's see when this came out. Oh, it ain't go. Okay, it ain't come out that long ago. It's like 37 minutes. It ain't come out that long ago. Because here's the thing, right? So now they got to go back and do that first part of it and this part. Mm-hmm. All right, let's see. So both of them responded. Both of them got it in, chat. Woo, I'm getting nervous. So let me see. Let me see. Now, let me see who we gonna go with first. Let's go with JBO response first because JBO was the one who made the challenges to it, right? She's the one that was in opposition. So let's pop her up there first and see what we get. Oh boy. Well, this is what I'm gonna do first, so we can put it all together. I'm gonna pop up what the questions was, right? What the judge had a question about. I'm gonna put those up, and I'm gonna give you the answers. So, what the responses that they came back with. Where was it? Okay. So let me put in case anybody is wondering what happened, because nobody really covered this, or nobody did really. And that's sad. All right. The judge asked these questions. She asks, are the defendants' claim about Section 120290 of the California Health and Safety Code, all that, at and about Section 2307 of the New York Public Health Code, the proper subjects of a motion of a judgment of acquittal under FRCP 29, motion 29, which is an acquittal. And then she gave some case law, and she said Rule 29 only authorized motions challenging the sufficiency of the evidence presented at trial. Her second question was, are any of the defendants' arguments about Section 120290 of the California Health and Safety Code untimely because he did not assert them before trial? And if so, did the defendant waive those claims because he did not raise them at the appropriate time? And then she cites a case law, right? So part one of the question deals with the argument JBO made and the evidence she used. Should it be, how could it be sufficient if it was never used at trial? So how are you making a sufficiency of evidence argument about evidence you never did use at trial? That's number one. Number two is, did R. Kelly raise his objections to the Health and Safety Code 120290 in the specified amount of time? Right, so that's what that is about. And I'll take that down now, and I'll go to, I'm going to pop up JBO's first, right? Because she's the one with the argument. She's the one with the problem. Okay, now, let me sit up. I done got nervous, child. Shit, and trust me, they was nervous when they was preparing this shit. Oh, wow. Okay. In his JBO, she says, defendant submits this letter in connection with court's order dated May 19, 2022, seeking additional briefing concerning defendant's Rule 29, challenges to Section 120290 of the California Health and Safety Code and Section 2307 of the New York Public Health Code. A. Defendant made a proper Rule 29 challenge to the government's proof that defendant violated Section 120290 of the California Health and Safety Code. Defendant also shows good cause for failing to challenge the applicability of constitutionality of the 2015 version of Section 120290, where the government failed to give proper notice of its intent to charge the jury pursuant to the modified repeated statute. Meaning that now she's okay, so now she's brought the jury in it. Okay, hold on. All right, let me tell you. So, where the government failed to give proper notice of its intent to charge the jury pursuant to the modified response. So, she's saying that this it should have been, how can I put this? That this wasn't part of the jury instructions. All right, it wasn't updated. Let me say that. Okay. She says the government charged defendant with 2 Mann Act violations alleging inter alia that defendant transported Jane to California with the intent of exposing her to herpes in violation of California Health and Safety Code Section 120290, Racketeering Acts 8 and 9. In his Rule 29 motion, defendant challenged the government's proofs on those counts in several ways, including arguing that the government did not prove every element of Section 120290 beyond a reasonable doubt. Okay, stop here. Now, you know this has to do with the text messages. And remember, I was telling you her argument was that based on the text messages, it wasn't that R. Kelly was doing all that enticing, inducing, praising, and coercing. It was actually the other way around. And they used those text messages to show that the mother was in cahoots with it. So that was her argument. And she says, hold on, what was that? Okay, the sufficiency of the evidence question is muddied by the fact that the jury was charged with a modified. Oh, wait a minute. You know what? I'm sorry. Change that part about the government. Um, that second part of her part A up there, this part right here, where the government failed to give prior notice of its intent to charge. I think she's saying that the government didn't give the notice in time enough for them to make the argument. So let's see which one she's trying to say. You know how JBO do. She loops things around. You know what I'm saying? It's kind of hard to see what the fuck what they be talking about, because you don't have the files, you ain't on the case, and you don't know what the hell where they going with this. But and you know how she do. All right. It says the sufficiency of the evidence question is muddied by the fact that the jury was charged with a modified version of the inoperable 2015 version of the statute. So that's what she's saying. So my bad. That's what she's saying. So it was an old version that was given to the jury for the jury to go by. She says the parties disagree whether the court was permitted to charge the jury pursuant to the government's instructions. The specific question of whether the jury was properly charged may not constitute a proper Rule 29 issue, but it is preserved for appellate review. So what that means is something, maybe it was objected to, and at some point somebody said preserve the record. And this is what that means. That all that language, what she just said, means preserved for appellate review. Since trial counsel objected to the court. Okay, if I would kept reading, I would answer my own self. Since the trial counsel objected to the court's jury charge, arguing that it did not reflect the operable statute or the law. And it says response found that, So, trying to see does her argument make sense. Okay, just give me a minute. Okay, so she's trying to say that she don't believe she's not sure if the government should have been allowed to use this 2015 version of the statute. That is what she is trying to say in this argument. A specific question. Okay. All right. Separately, defendant pointed out in his Rule 29 memo that the 2015 version of the statute is unconstitutional and that neither the government nor its court possess the authority to rewrite the statute to save it from a constitutional challenge. Oh, shit, JBO. JBO done went there. JBO done went there. JBO done went there on your ass. I told you. This lady put pressure on the law, the judge, and every goddamn body around. She's not fucking around, y'all. Ooh, well played. Well played. She said that she's not sure that this court, meaning the lower court, meaning it's going to go higher, has the authority to rewrite the statute to save it from its constitutional challenge. Baby. Okay, I told y'all. When them motherfuckers be using the primary law and mandatory law, all that shit like that, that shit there is hard to to defeat, especially with some case law shit, because that's the laws that you must go by. It must be enforced. And the second one is the one that the court must enforce, right? Throughout proceedings. So it's kind of hard unless they can come up with something to show that you are just factually incorrect about those two, mandatory law and primary law. It's just that simple. And that oh my gosh, girl, she be swinging, baby. Let me keep reading. Defendant concedes that a constitutional challenge to a statute is not equivalent to a sufficiency of the evidence challenge. Oh, she might have killed herself right then. Uh-oh. So you know what? Remember when I said that she would have been better off putting these on an ineffective assistance of counsel, which is a constitutional challenge, instead of the sufficiency of evidence challenge. Yes. Okay, let's see. Oh, defendant also concedes that at trial, counsel did not specifically challenge the constitutionality of California Health and Safety Code, Section 120290, but that it is because the government did not apprise the defense of its intent to have the jury charged pursuant to a repealed version of the statute that it also rewrote. So I was right. She's saying that you didn't put it out there. So how can she challenge it? Remember I was saying, I went back and said maybe she's saying that you didn't put out there soon enough for me to challenge. So yeah. Oh shit. Oh, defendant. See, I kind of speak JBO. Defendant shows good cause for failing to challenge the statute in pretrial motion as it did the New York Public Health Code provision. Y'all know when I get excited, I can't speak and I can't see. Oh shit. Because she is killing it, but she also shot herself in the foot. It said defendant shows good cause for failing to challenge the statute in pretrial motion as it did the New York Public Health Code provision. Case law. Even if this court were to conclude that trial counsel failed to timely raise a constitutional attack to California Health and Safety Code, Section 120290, trial counsel was ineffective for failing to do so. Boom! She said what I said. Boom! I know it. God damn it! I knew it. I told you. Woo! Damn, girl, I speak JBO. But you didn't make the right challenge in your motion. So correcting it now, this is gonna be denied. Okay, let's see. All that aside, defendant also raises a sufficiency of the evidence question by arguing that even if the elements of the statute were properly charged, the government did not prove that defendant was contagious, infected, or had the capacity to transmit herpes during the sexual encounter he had with Jane in May 2015. Defendant also argued that the government's proof was lacking in so far as it failed to show that defendant acted willfully with knowledge of the y'all know I get choked up, a coincidence, consequences. I'm sorry. Okay. The wrinkle here is that this court cannot answer this Rule 29 question without first deciding whether the jury was properly instructed pursuant to the applicable law. Defendant cannot be said to have waived his challenge to the jury charge where he expressly objected to the instruction charge and offered the operable version of the Section 120290. Because the government failed to put defendant on notice that it was charging defendant with a rewritten version of the 2015 statute until the trial was nearing at its end. Oh, okay. Saying she said she didn't have time. Defendant shows good cause for failing to move to dismiss the counts pretrial or challenge statutes. That's the part 2 of that question. It says statute's constitutionality. Alternatively, trial counsel was ineffective as described. Super means above somewhere. It says, notwithstanding all of the above, the court must decide whether the jury was properly instructed pursuant to the applicable law to determine whether the defendant's sufficiency of the evidence challenge should be sustained. Wow. And that's when I was telling you it was apparently there was an objection raised about this at some point. Right. That's what I was saying. At some point during the course of the trial. It says part B, defendant's Rule 29 challenge as to New York public health law. It says defendant concedes that his challenge to New York public health law, section 2308, are constitutional in nature. Defendant's constitutional challenge to 2308 are preserved for appellate review. All right, so she's telling me what she's gonna do. And let me read this footnote. It says the government cited to the statute in the indictment, referencing the statute with an effective date of 1998. The mere cite could not have put counsel on notice that the government intended to charge an inoperable version of the statute or that it intended to modify the elements. But if this or any other court finds that the indictment did put defendant on notice, trial counsel was ineffective for failing to challenge the indictment and the constitutionality of the intended modified statute pretrial. No possible trial strategy exists for this omission where trial counsel clearly understood its importance when it challenged the New York public health law or on similar grounds. Wow. Wow, JBO. Let me come on around here on the front. See what y'all think. Oh my gosh. What y'all think? Did you think she Thank you, Karen. Did you think she yeah, it is. Did you think she knocked it out the park or what you think? Like, whoa. I told y'all that when I first read it, I said this should have been on ineffective system of counsel. It should have been, a constitutional challenge, not sufficiency of the evidence. And JBO, boom, came right on back and said, boom. That's what I meant to do. That was like, boom. I was typing too fast, hole. That's what I meant to do. I meant to put it saying it was ineffective. That's what I meant to put on. That's what I meant to run that on. Okay. Oh man. Yeah. Yeah. Because she didn't make the proper challenge. I mean, nothing to do about that now. Yes, fast. I'm always laughing. Huh? I'm always in a good mood. Until somebody make me not be in such a good mood. But that is crazy. She can't. Now I'm scared to see what the government said. Oh my goodness. Oh, let me take this down and let me put the government up there. The government. What the government say? Let me pop the government up there. Ooh. Okay. The government says, dear Judge Donnelly, the government respectfully submits this letter pursuant to the court's May 19, 2022 electronic order directing the parties to address two questions. With respect to the court's first question, whether Rule 29 of the Federal Rules of Criminal Procedure, Rule 29, is the proper vehicle to challenge Section 120290 of the California Health and Safety Code and Section 2307 of the New York Public Health Law. The government respectfully submits that it is not. Yeah, because she gave you the answer. The judge already gave you the damn answer. So, yeah, you come right. That's exactly what I would have did. My first couple of words, no, it ain't. Thank you for prompting me so I can answer you correctly. Hell no, it ain't. A good catch, Judge. That's why you the judge. And I asked to sit back behind these tables. Okay. Boy, that's funny as hell. By its plain language, Rule 29 allows the court to grant a judgment of acquittal only when there is insufficient evidence to sustain a conviction. Well, again, the judge already gave you the answer. All right, it says case law. Rule 29 only authorized motions challenging the sufficiency of the evidence presented at trial, which is what the judge had already typed in her shit. So y'all just copied and paste what the judge said. Bam. This shit chills the hell out of me. Baby, they ganging up for y'all ass, baby. Team Kel. Baby, I don't know what to tell you. They ganging up for y'all motherfuckers. They are tired of y'all and all the motherfucking motion, all that crying, all that bullshit y'all got going on YouTube. They are tired of it. oh, 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 I can't believe. God damn, you just copied and pasted the shit. I would have put in a little bit more. I mean, the first few sentences wouldn't be like copy and paste what the judge said. Damn, you couldn't even decorate it a little bit, disguise it and shit. Crazy, y'all. JBO got them crazy, baby. Wait a minute. They teaming up on her motherfucking ass. See, they see how she coming. I told you that lady ain't nothing to be fucked with. And they doubling up on her motherfucking ass. This the double up to her shit. Fuck that. And they don't have a tour named that, the double up tour. I think so. Okay, it says, although styled as a Rule 29 motion, the defendant in essence moves to dismiss the superseding indictment for failure to state a claim. Rather, the vehicle through the defendant could not have properly raised those challenges is Rule 12. Boom! What Lady Legion was talking about, or Rule 12. Hell no, they listening, y'all. They listen. We gonna shut this motherfucker down. Hell no. Hell no, baby. We trust nobody. Hell no. Get the fuck up. Karen J, switch over the motherfucking music. Change this shit to Our Channel by James Harris, and let's get the fuck out of here. Hell no. What you mean? What you mean? Hell no. Now wait a minute. Listen. Hell no. Wait a minute. Indeed, the defendant did not raise challenges regarding the counts that reference Section 2307 through Rule 12, and the court denied those challenges. Those rulings remain the law of the case, and the defendant has offered no basis to disturb them. With respect to the court's next question, whether the defendant's challenge to Section 120290 of the California Health and Safety Code is timely, the government respectfully submits that it is not, as set forth above. The proper vehicle through which the defendant could have raised its challenge in regard is Rule 12, specifically Rule 12B. What I told you it's Rule 12B. Rule 12 prescribes the time by which a defendant must make a certain Rule 12 motions, while motions that the court lacks jurisdiction may be made at any time while this case is pending. Certain motions must be raised by pretrial motion if it's the basis for the motion is then reasonably available, and the motion can be determined without a trial on the merits. FRCP 12B. Among the motions that must be raised pretrial when those conditions are met are those for a defect in the indictment, including failure to state an offense, FRCP 12B. Significantly, in 2014, Rule 12 was amended to remove language that allowed the court at any time while the case is pending to hear a claim that the indictment or information fails to state an offense. FRCP 12 Committee Notes on Rule 2014 Amendment. As in a committee note explained, the specific charging error was previously considered fatal whenever raised and was excluded from the general requirement that charging deficiencies be raised prior to trial. The Supreme Court abandoned any jurisdictional justification for the exception in case law, insofar as it held that a defective indictment deprives a court of jurisdiction. And that's FRCP 12 Committee Notes on Rule 12 2014 Amendment. Here, the defendant challenge is properly characterized as one of failure to state an offense and is not jurisdictional in nature. As a result, the defendant was required to file such a motion prior to trial. In essence, the defendant argues that Racketeering Act 8 fails to state an offense because the alleged sexual activity was not activity for which a person can be charged with a criminal offense, because the version of the California state statute in effect in 2015 and referenced in the indictment has since been repealed. His claim is analogous to one what is that? Posted. I'm sorry. What is that? Persisted. Okay. In case law. I can't see shit. Where the defendant challenged his conviction for having falsely pretended to be an officer of government of the United States, to wit, a member of the House of Representatives, specifically objecting that the indictment did not charge a crime against the United States. Case law. As the Second Circuit explained approvingly in case law, abrogated on other grounds by case law. You know, when I read slow like that, I cannot read. Okay, let me get my shit together. Okay. The defendant in Lamar argued the court lacked jurisdiction to hear the case because a member of the Congress is not an officer of the United States. Lamar 240 U.S. at 64. But as Justice Holmes explained, nothing can be clearer than the district court, which has jurisdiction of all crimes cognizable under the authority of the United States, acts equally within its jurisdiction whether it decides a man to be guilty or innocent under the criminal law, and whether its decision is right or wrong. The defendant argues went therefore only to the merits of the case. Case law, oh Jesus. Rejecting post-trial challenge to an indictment charging attempted aggravated identity theft, where the statute did not allow charges based on attempt because it was one for the failing to state an offense, was not jurisdictional in nature and was therefore untimely. According to the defendant's challenge in this regard to Racketeering Act 8 is not jurisdictional, and any Rule 12 motion raising such a challenge is now untimely. The defendant has offered no cause, let alone good cause, for his untimeliness, and to the extent the court construes his Rule 29 motion as Rule 12B motion, it should be denied on that basis. Let me read all these fucking footnotes. All right, number one, in height, the district court rejected the government's argument that the defendant's Rule 29 motion, which was in fact Rule 12 motion, was untimely because the version of Rule 12 in effect at the time allowed the defendant to move to dismiss an indictment for failure to state a claim at any time. Rule 12 was subsequently amended in 2014. As set forth below, the previous version of Rule 12 no longer applies to the Rule 12, now requires that motions to dismiss an indictment for failure to state an offense in the circumstances at issue here must be made pre-trial. As reference. As a result, the district court's ruling in height regarding the timeliness of the defendant's Rule 12 motion is not applicable here. Rule 12 C3 makes it clear that a motion filed after the deadlines for making a Rule 12 B3 motion, i.e., after the trial has commenced, is untimely and that a court can consider an untimely request only if the party shows good cause, a standard the defendant has not and cannot meet here. Case law. We believe that the necessary effect on the congressional adoption of Rule 12b-2 is to provide that a claim once waived pursuant to that rule may not later be resurrected either in the criminal proceedings on or in federal habeas in the absence of the showing of cause which that rule requires. Case law. There can be no dispute that prior to trial, the basis for the motion was reasonably available and the motion could have been determined without a trial on its merits. The indictment clearly referenced the version of section 120290 effective of as of 1998 reference, which version remained in effect at the time of the conduct charge in Racketeering Act 8. The government proposed jury charge filed on July 2nd, 2021, and submitted jointly with the defense also referenced the 1998 version of the statute and explicitly quoted its language reference. Okay. Oh, I chopped that up, child. Ooh. Anyway, boom. Oh shit. Oh my God. Honey, they listen. Shut this motherfucker down. Let's get out the hell out of him. This is crazy. Hey, Leslie. Whoa. Baby, when I tell you, they are doubling up on them motherfuckers. They doubling up on Team Chaos. Honey, let me go and put this up here. So that was crazy. Now, the judge covered her ass. Um, the government gave a good, detailed explanation. JBO gave a good argument, but she did say they should have been ineffective. Probably gonna get denied. But hey, they own the case and make mistakes. So it is what it is. Shit. And if you're thinking that the judge and them can get in trouble for kind of directing them to where to go, she did it in a matter. She directed both of them to where to go. So you can't say that she. I mean, well, we know what it is, but upon somebody taking it up somewhere else, you can't sit up there and say, she helped them, and then you can't say that she didn't help your ass. Because she directed both of y'all to where to go to find the answer. She did your jobs for you, pretty much what it was. But y'all know what it is. Oh my gosh. Oh, you got to love it. This crazy. Yeah, she gonna take it to the next level. This crazy as hell. Like, are you serious? Are you fucking serious? Oh man, and I can't believe the goddamn government just politely copied and paste what the hell Judge Ann said, as though she already did the work for him, and was like, huh, that's crazy as hell. Mm 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 mm. Ha. But shout out to Lady Alicia. She came on with that Rule 12 motion what it should have been. And she was saying, I think she was saying, well, it should have been A. And I said, no, I think it was B. Should be B. Because it deal with pre-trial. So shout out, baby. Shout out. Boom, boom, boom. We be knocking it out. We be knocking it out. Yes, honey. So hey, Love Spare, and who else we got? And Leslie Jennings, and I said, hey, Faf. Mm, 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 mm. Well, y'all, honey, that's my time, honey. Ooh, sha. All right, y'all. I will holla. Yes, honey. Yeah, you gotta rewind because this is crazy, baby. They listen. I'm going to start talking without all that profanity and all that extra because they are listening. I have to be a pillar of the community amongst my peers and be professional, even when the setting is unprofessional. Okay, I'll retain and restrain all my cursing to be taken up on Twitter and the Facebook and Instagram if they lets me curse. Okay, all right, y'all have a nice day, and I will holler at you some other time. Until the next live, be good to each other, be good to yourself. Do some nice for each other. Goodbye. This is our channel by Angie signing out, and I am the Angie of the channel by Angie, and I would like to say goodbye. Okay, guys, I'm exiting without any music, just on my white horse that's on a floating blanket, on a floating rug with pixie dust and unicorns, just like the Lucky Charms cereal all around my head. I am leaving this life. Smooches. Goodbye.